Not the best setup here today. Hopefully that will work. Actually, let's see if I can't move this forward a little bit. Okay, well, that's going to have to do. We're going to talk about the Supreme Court today. Alright, this is actually like structure and function of the Supreme Court. Some of this will be a little bit of a review from the video that you had before. You're welcome. First, understand, Article 3 of the Constitution of the United States of America is the article that mentions the Supreme Court. It is the only court that is actually mentioned by name in the entire Constitution, and it is the only court that's covered under Article 3. In fact, as I mentioned yesterday, Article 1 says that Congress has the right to establish inferior courts. Right? Right now, our Supreme Court consists of 7 justices, 1 chief justice, and 1 vacant seat. Right? But the court consists of 8 justices and 8 associate justices, 1 chief justice. Right? That's something that's been established by Congress over time and part of our precedent. There's actually nothing in the Constitution that mandates or dictates that we have a 9-person Supreme Court. Okay? When you go all the way back to the foundation of the United States of America, we did not have 9 men on the Supreme Court of the United States of America. We had fewer. And during the Great Depression, FDR actually attempted to pack more people onto the court that would have been sort of ideologically aligned to him in order for him to get more policies implemented. All right. When the position of Chief Justice is vacant, the President of the United States can either appoint a sitting Associate Justice to be the new Chief Justice, or he can go outside the court altogether and appoint somebody who's not even on the Supreme Court to just automatically jump everybody and become the Chief Justice. All right. The Supreme Court's the highest court in the land, and it's really the last sort of avenue that anybody has to get anything done. All right. The primary power, or the specific key power of the Supreme Court of the United States of America is that of judicial review. Okay? True or false, the term judicial review shows up in Article 3 of the Constitution.
False.
Correct. Okay? It's actually not in the Constitution of the United States of America. Article 3 doesn't specifically mention that. Instead, it's established with Brown versus Board of Education. Where have you been? You get lost?
Yeah,
Were you sitting in Miss Brown's room or Miss Baker's room this whole time?
yeah.
Were you really? I mean,
I went to the gym and never realized that.
oh, okay.
And then
Okay, you went to the gym. So you weren't sitting in Mr. Comerford's English class for the last, 15 minutes?
no.
Okay, fair enough. So here's the thing. Judicial review is established in Marbury versus Madison, but it is not actually mentioned in the Constitution. Okay? And if we had a little bit more time, and maybe I'll show you all of this because it's a wonderful conspiracy theory, and everybody loves a good conspiracy theory, right? After the AP test, when we have a little bit of time, we'll go over Marbury versus Madison in a lot of detail, and I'll explain to you why that case sort of came out in the manner in which it did, that established judicial review in a very sort of conspiratorial way. I don't even know if that's a word, but we're going to use it. All right. So judicial review is established with Marbury versus Madison. All right. Over the course of history, more than 1,000 state laws have been declared unconstitutional. More than 1,200 federal laws have been declared unconstitutional. Presidential actions have been declared unconstitutional. Usually students struggle with that concept of presidential actions being declared unconstitutional. I'm going to assume you kind of get that because you watched Donald Trump twice now try to implement a travel ban on people coming into this country, and twice it has been declared unconstitutional. All right.
So if you were to implement like something that
Is that shaking or is it me? Okay.
So if Donald Trump implemented something to make it like make them more searches, like search them heavier whenever they come into the country, would that be legal?
Here's the problem, is it's hard to say, because it's based upon individual justices' interpretations of the law. As well, apparently in this case, I read an opinion from a judge that basically said that if Obama had implemented this travel ban, it would have been constitutional, but because Trump implemented the travel ban, it's unconstitutional, based solely off of the rhetoric that Trump espoused during the campaign. Because Trump said he was going to ban Muslims. Well, now that becomes like a violation of basic rights based on discrimination of religion, right? Which apparently violates the First Amendment of the Constitution of the United States of America. If it was done solely for reasons of national security and Trump hadn't run his mouth, there are actually people that believe that it would have been acceptable.
Necessary and practical laws for Congress would pass it.
Well, Congress would be different than the president.
Yeah.
But for the most part, historically, we have allowed the President of the United States to be the one that handles foreign policy issues, which is what this would fall under. I mean, there's nothing in Article 2 that specifically says he gets to control who does or does not enter the country. But again, I think you could imply that from that regard. All right. The Supreme Court will interpret both the Constitution and individual statutes or laws, and the Supreme Court can overturn itself. All right, so it can overrule earlier decisions. Plessy versus Ferguson is overturned with Brown versus Board of Education. All right. As far as the jurisdiction goes, the Supreme Court has both original and appellate jurisdiction. The vast majority of its cases are appellate jurisdiction. All right. It only has original jurisdiction in issues directly involving the states or ambassadors. All right. Appellate jurisdiction comes from the Court of Appeals. You cannot jump the Court of Appeals. You cannot try something in the district court and then automatically go to the Supreme Court. It has to go from district to appellate to Supreme. Okay. Additionally, we talked about this idea of concurrent enrollment. Concurrent enrollment means what? Not a clue. Because what are you watching? Fraggle Rock?
No, I watched some top 10 videos.
Oh my lord, son. Okay. Concurrent jurisdiction means that it is both the jurisdiction of the state and the national government. So you can actually have something that goes from a state court system all the way to the state Supreme Court and is then challenged in the national and the federal SCOTUS, right? Supreme Court of the United States. Okay, but again, those are appellate in their jurisdiction. And you went over this, you saw this with the little video when I was out last week. There have been thousands, every year there are thousands of petitions to the Supreme Court. They grant very, very few of them, right? Well less than 10%. Basically, they do about 90 a year. Okay? The rule of 4 is in place with this. What the rule of 4 means is that 4 justices have to agree to hear the case. All right? So when the actual writs come to the Supreme Court, they go to the actual law clerks of the justices, not the justices themselves. Again, thousands a year. It's almost a full-time job just to read all of those things. Right? So the clerks are the ones that are reading it. When the clerks find something that they think that their judge might be interested in hearing or ruling upon, they'll take it to the judge. Judge would then look at it, say, all right, yeah, I kind of like this, so I want to rule on it. They then give it to their colleagues, and they hope that 3 others will say yes, so they got the rule of 4. Okay? There are a number of reasons as to why the court system, or why the Supreme Court doesn't hear cases. Okay, sometimes they'll say that it lacks a substantial federal issue, meaning it's actually not a federal case in the first place. Sometimes they will say that the party that's bringing about the lawsuit lacks standing. We talked about that yesterday with the guy who sued about Ted Cruz's birthrights. Right? But 3 and 4 here are the primary reasons as to why a case is not heard by the Supreme Court. Okay? A lot of the times the Supreme Court will actually agree with the appellate court decision, in which case they don't need to hear it. Right? We talked about that term precedent. Does only the Supreme Court set precedent? Caitlin, what were you doing? Shaking your head no? Good job. That's right. Okay? It is not just the Supreme Court that sets precedent. If an appellate court makes a decision, right, and nobody overturns that decision stands. That's the law of the land. All right? And so if the Supreme Court agrees with the appellate court's decision, they might not hear the case because there's no point in it, right? I mean, what are you going to do? Have 9 justices that are like, yeah, we agree. Done. Right? There's our whole opinion. We agree. Period. It's a waste of time. They're not going to do that. Okay? Additionally, they don't want to hear hot potato issues, right? Or what we could call politically hot issues. All right? So if there's something that is very partisan, right? Or something that lacks sort of a decent understanding as to its constitutionality or its importance in the law, the Supreme Court frequently will not want to hear that kind of a case because they don't want to be making some sort of political statement. That's not their job. And most justices don't want to do that. And whether on the liberal or conservative side, most of them do not want to do that at all. All right? Once they do accept a case, basically there's 2 options at that point. 1, they can ask for additional information and hear arguments. Or 2, they can simply decide right there. Okay? Once that little rule of 4 works on their little Fridays when they talk about cases, they can simply talk it out amongst themselves with the information that was already presented to them and go ahead and render a decision. All right? They don't have to hear oral arguments on it. The way the actual Supreme Court works, their little sessions or their terms begin in October. They run all the way through the end of June. All right? Monday through Thursday, they will actually hear cases. All right? And what that means is that Monday through Thursday, they'll hear oral arguments. They'll read the briefs. They'll read any sort of amicus curiae brief that happens. They'll actually hear oral arguments from each side. All right? That happens Monday through Thursday. And in order for that to happen, right, we have what we call the quorum of 6. There has to be 6 justices sitting on the bench at that point in time for cases to proceed in that manner. Doesn't have to be all 9. Makes sense why it's not all 9, right? Because if we required 9 people to be sitting on the bench, what would we have done in the last year? Nothing. Because we've only got 8, right? Obviously, when we're talking about Ruth Bader Ginsburg, is what, 84 years old? 86 years, 80 something, she's in her mid-80s, right? I'm going to go ahead and assume at mid-80s, she probably needs to see a doctor a fair amount. Okay, so she might miss a little bit of time to see a doctor. All right, that's okay. We have provisions built in for that to ensure that.
But it still takes 5 to pass, like the rule.
Yeah. All right. So that way, so long as 6 are there, you can hear the case. All right. Now, once the cases have been heard and a decision has been rendered, and the way decisions are rendered, it is a simple majority. Okay? If it goes 5 to 4, you're good. Right? If 5 out of 4 justices, or 5 out of 9 justices agree, that's the law of the land. Alright? Now, once that decision has been made, we have opinions that are written. And most cases you will see multiple opinions per case. Alright? And this shouldn't come as a surprise to you because you did this when you did your little SCOTUS PowerPoint assignment. Right? The first kind of case, or the first kind of opinion that you can have, right, is a unanimous opinion. That means all 9 judges agree. All right, that actually happens more frequently than you would think. Okay? I mean, especially when you consider Scalia and Ginsburg are about as far apart ideologically as they could get, yet a lot of the times they're going to agree on cases legally. All right. Next, you have the majority opinion. Okay, the majority opinion is the opinion of the majority. Okay, so if you have 5 or more, that is called a majority opinion. All right. That is what actually sets the legal precedent moving forward. Okay? Those people that are not in the majority, they write the dissenting opinion. And that's what you're going to do for your final project grade. Okay? Is you're going to write a dissenting opinion. Okay? And then additionally, you have what are called concurrent opinions. So, concurrent opinions are opinions that side with the majority, but for a different reason. Because our legal system is so complex, right? What you could have is you could have, let's say, a case about abortion, right? So you look at Roe versus Wade, and you might have a liberal judge say that under the implied right to privacy, a woman has a right to abort a fetus, right? Or in reality, a woman has a right to engage in whatever private medical care she so desires, right? That's what you're saying. you very easily could have a conservative justice that would make a decision in Roe versus Wade that would simply say, hey, state of California says that abortion is legal, and that is a state right issue. Therefore, it is not the job of the court or the authority of the court to overrule a legal law, a constitutional law from an individual state, right? Is that a conservative philosophy or a liberal philosophy? States' rights, liberal or conservative? Conservative. Okay? Right to abortion, liberal or conservative? Liberal. Yet both of them came to the same conclusion, didn't they? Right? One of them said right to privacy, abortion okay. The other one said states' rights. If California wants to make it legal, go ahead. Right? So they have reached the same conclusion. They are both of the majority opinion. However, you're definitely going to get a concurring opinion. Right? And that means that whoever doesn't write the majority opinion, they're going to say, okay, hey, we made the right decision, but here's the real reason why it was the right decision. Right? So it's a different reason. Alright? Now, when it comes to writing these opinions, these are wildly important. Alright? If the Chief Justice is in the majority, he is going to assign the majority opinion to whomever amongst the majority he wishes. Alright? If he's in the minority, then whoever the senior-most member on the court is gets to assign the opinion to whomever he so desires. So, if you go back and you look at the case that I just gave you as an example, right? Let's say for the sake of argument that you had the 4 liberal justices on the court that all said, no, abortion should be legal, woman's right to choose. Okay? And then you had Scalia, okay, who's very fundamental constitutionalist, who says, hey, doesn't say in the Constitution that you can't do it, and California wants to make that law, they can make that law, done. Right? If the Chief Justice is with the majority, he can assign that opinion to whomever he wants. And if he assigns the opinion to Scalia, then we didn't make abortion illegal. And the way Scalia writes the opinion doesn't actually make abortion legal. It makes it legal in this case. Okay? But his opinion actually says that it's based upon what the state wants to do. So if the state of Alabama says, no, here abortion is not okay, sorry, then according to Scalia, that's an acceptable opinion for the state of Alabama to have. Okay? Conversely, if you have, no, he's actually awake. I don't know why he's snoring. Okay? I know. Okay? Conversely, if you have one of the liberal justices write the opinion, and they write the opinion that says, no, abortion is legal because it's a woman's right to choose, and that's the basic inherent freedom of being a human, then that sets a precedent across the board everywhere that abortion is legal. And now Alabama cannot make it illegal. It's not a state right issue. Okay? Instead, it is a right to privacy issue. Okay? And that's what this slant is right here that this is talking about. Okay? And this is why the individual that writes the opinion, it's wildly important who does or does not write the opinion. Okay? I don't care about any of that. The whole purpose of the opinion is to make this known to the court as to what they want. All right? What that does is that leads to the precedent that we're trying to set, okay? And it tells people what we're doing moving forward. All right? So it does provide that precedent for future cases. Sometimes in the opinions they will actually drop hints to Congress or to whomever that basically says, hey, look, what you did here is not acceptable, it's illegal. However, if you did this, it would be all right. All right, and that basically tells the state or Congress, all right, let's go back and do this the way that it would be actually legal. All right, now, there are ways, believe it or not, to get around Supreme Court decisions. Okay, so there are some opportunities that we have to supersede Supreme Court law. All right. The easiest way to supersede Supreme Court law is to, and sadly this is the easiest way, amend the Constitution. Now, how easy is it to amend the Constitution? Not easy at all, right? But if you have 5 out of 9 justices that say, hey, this action is unconstitutional, and then you're like, hey, let's write a little amendment here that says this action is constitutional. Done. Alright? That being said, State Supreme Court for the state of California actually set a precedent that said that they can declare that the Constitution is unconstitutional. How the state Supreme Court of the state of California did this is beyond me. Okay? But a little over a decade ago, the state of California passed a state constitutional amendment that said marriage is defined as a union between one man and one woman. This is the state of California, mind you, that passed this. Right? Our most liberal state said no gay marriage. And they amended their constitution. It went before the state Supreme Court. The state Supreme Court said, no, that's unconstitutional. So apparently you can declare the Constitution itself to be unconstitutional. Alright? Another way to do it is to simply ignore whatever the Supreme Court says. I'm going to tell you right now, if I was Donald Trump, right, and this is how you know I'm straight gangster and I don't give up. Alright? Because I'm going to tell you right now, if I was Donald Trump, and when they declared my second little travel order as being unconstitutional, I'd have looked at them and been like, yeah, I don't care, I'm going to do it anyway. Stop me. Right? Because I'll simply have my little agents in my executive branch, because those agencies are a part of the executive branch, Homeland Security and TSA. Yeah, we just ain't going to let them people off the plane. Oh, well. What are you going to do about it? Because there's nothing you could do about it. Okay? In fact, we have some precedent of this. Andrew Jackson had that famous line of, Marshall made his decision, now let him enforce it. Because John Marshall said that Andrew Jackson could not kick Native Americans off of their homeland. And what did Andrew Jackson do? He sent his little army down there, kicked them off, and it became known as the Trail of Tears. Alright? You can have state and local governments, right, that simply decide not to carry something out as well. Good example of that would actually be desegregation. So there were southern states when after the decision of Brown versus Board of Education, they were basically like, yeah, I don't really care, I'm not going to do that anyway. Right? Eisenhower had to mobilize the National Guard to desegregate certain schools. There were actually southern governors that basically said, if you're going to make black kids go to school with white kids, we're going to stop school. They just shut down all schools altogether. Rather than make white kids go to school with black kids, they were just going to send everybody home, and nobody goes to school in the state of Mississippi no more. Alright?
Mr. Baker.
What's up?
So, if Trump did that, could they impeach him?
They could try, but I don't think that they would succeed. One, the Republicans aren't going to impeach him. And the Republicans control it right now, so I don't think you would get that. Two, we have a long-standing, look, Obama, Bush, Carter, Reagan, they all had travel bans. All of them. None of theirs were unconstitutional. Right? And the argument that I heard is the reason why it was, quote-unquote, unconstitutional is because Donald Trump said in a campaign, ban all Muslims. Well, now you're telling me that you're making some sort of decision about what his motivation behind something is. And that, you can't determine that. Right? You cannot tell me what my motivation is in my own actions. That's just not, anybody that thinks they can do that is a moron. Because that's like me telling you how you feel. You can't do that.
Could they impeach him?
Right? Even if you came in here crying, right? I can't be like, oh, you're sad. Because I don't know that. Right? Maybe you're crying because you were just laughing that hard. Maybe you're crying because you're in that much physical pain. You're not sad. You hurt.
Tears of joy.
Right? So for a court to sit there and make some sort of arbitrary decision that says, oh, you're doing this because you're racist and you hate the Muslim religion, you can't prove that. Now, do I think that he hates Muslims? Yeah, probably. Stevens and Soder are not on the court anymore. Soder is replaced by Sonia Sotomayor. Stevens is replaced by Elena Kagan. But Ruth Bader Ginsburg and Stephen Bear, they're both on the court. Those are the 4 liberal justices. We have 3 conservative justices, because Scalia is dead, right? So we got Roberts, we got Clarence Thomas, who's incredibly, he and Scalia were like redonks conservative. And then Anthony Kennedy is your moderate, right? The third real conservative is Alito. Alito's a true conservative, and he took over for Sandra Day O'Connor in 2006. All right. Again, this is a little out of date, but this is part of the reason why Ruth Bader Ginsburg is going to do everything in her power to remain on the court until Trump is out of office. And it's part of the reason why the Republicans were so adamant about not letting Obama fill Scalia's seat. Because if you look at the makeup of the court, right, prior to Scalia's death, you had 4 conservatives: Thomas, Scalia, Roberts, and Alito. You had 4 liberals: Bear, RBG, Sotomayor, and Kagan. And then you had 1 guy who pretty much swung in the middle, right? And that's Kennedy, and he would go either way. Kennedy is a Reagan appointment. He's been on the bench a long time. All right. That being said, if you look at Soder and Stevens, they're both appointed by Republicans as well. Yet when they were on the bench, they were fairly liberal. All right. So fairly liberal appointees in that regard. All right. That takes us to the end of the. Should take us to the end of the Supreme Court. Yeah. We'll go through judicial activism tomorrow.